Okay, hello there. I'm criminal defense attorney Nate Amendola, criminal law in plain English. Today, the topic is what happens if my case gets dismissed, or what does it mean if my case gets dismissed with prejudice? Okay, so let's think about this. There are a number of different ways a case can get dismissed, okay? And we'll talk about that in a different video, but some of them now, for the purposes of this video, are, for example, if your defense attorney files a motion for dismissal under what's called Commonwealth v. Benedetto, which is a case that stands for the proposition that the criminal complaint must be supported by probable cause for each and every element of the offense. If the case is not supported by probable cause for each and every element of the offense, the judge can and should dismiss the case. There are a bunch of other ways to dismiss a case too. For example, if you're on for trial, you show up the day of trial, and for whatever reason the Commonwealth decides not to go forward. That's rare, but maybe they answer not ready, for example, because one of the key witnesses is not there, and the defense attorney moves for dismissal, and the case is dismissed. But here's what I want you to understand. In many situations, especially the ones I've just told you about, the judge will dismiss the case without prejudice. Okay, so there's two ways to dismiss a case: dismissal with prejudice and dismissal without prejudice. A dismissal without prejudice is far more common in Massachusetts courts here. What that means is it is dismissed without prejudice. Therefore, the Commonwealth can fix whatever deficiency is part of the charge and represent it or bring it back, or have the police reapply for a new criminal complaint. So a dismissal is great. Wow, my case is dismissed. But it's a great thing, but it's sometimes just not enough, because sometimes the Commonwealth can bring the case back through various mechanisms. It's impossible to tell under what circumstances those are going to happen. You should talk to your lawyer about that. My experience is that yes, sometimes the case is brought back and recharged, but certainly oftentimes it's not. I think particularly with a case like a domestic violence case, where the alleged victim doesn't show up or decides not to participate in the prosecution, and there's a motion for a dismissal and the case is dismissed. Oftentimes, in my experience, those cases are not reinvigorated, so to speak. So, and the same thing with like a motion to dismiss under Commonwealth v. Benedetto. Certainly, I've had cases like that where we've presented a motion and we've been meritorious on those and victorious, and the deficiency is such that the Commonwealth really can't fix it. There may be some legal impediment or some factual impediment that makes a representment or another some edits to the criminal complaint, and therefore they submit it again to the reviewing magistrate. I found that there are certainly situations like that, and sometimes I suppose I could say that's more often than not. The Commonwealth cannot revive the case. I mean, technically they have the ability to, but they don't. So dismissal without prejudice is great, and it's certainly and it's definitely the norm. What's a little different is a dismissal with prejudice. These are really, really rare. And the dismissal with prejudice means that the case has been dismissed and there's nothing the Commonwealth can do to revive the case. Okay, they can't file a new criminal complaint, they can't re-indict it, whatever the case may be. Typically, these are for major, major problems. Like, for example, prosecutorial misconduct, which could include police misconduct, not necessarily the prosecutor doing something wrong, although that's possible too. Some sort of impediment to the proceeding, whether it's a grand jury proceeding or a criminal complaint. Some sort of major discovery violation that has, sort of, maybe there's been a motion to dismiss for a discovery violation that was without prejudice. The case is brought back, and the government continued with its malfeasance and has made numerous discovery violations. In such an instance, that is sometimes, again, these are rare, but that is gives rise or gives grounds for the judge to dismiss with prejudice. So without prejudice, the case can come back. Um, with prejudice, it's over. The Commonwealth cannot bring the case back. And again, I really want you to understand this. With prejudice is extremely rare. There's got to be some major issue with the case, or particularly the procedure by which the case was charged, or some mishandling of it. That is really the only time I've seen dismissals with prejudice. The next question I get a lot is, okay, so my case has been dismissed. That's great. Do I get some sort of piece of paper or some sort of certificate or an order from the judge showing that the case has been dismissed? So not really. Most of the time, the dismissal is provided in the docket entry on the court system. So there'll be like the date, April 10th, 2026 or whatever, defendant's motion to dismiss allowed. Okay, and we'll say allowed on the docket entry. Sometimes there might be an attachment on the docket entry that includes the judge's decision. And sometimes the judge will write in the margin, dismissed or allowed, motion to dismiss allowed, allowed signed Judge Johnson. Okay. Sometimes in a particular, if there's some sort of legal issue or some unique issue, or the motion is particularly complex, the judge actually might write a decision, decision on defendant's motion to dismiss, allowed for the following reasons, I'm allowing the dismissal, or denied for the following reasons, I'm denying the dismissal. You see that a lot more in Superior Court, although you do see it in District Court, but it's much more prevalent in Superior Court. So in that instance, I suppose in some case that's sort of official documentation. It's an order of the court that the case has been dismissed, but most often you see it in the docket entry. That brings me to the next question we get asked a lot is, okay, now that there's been a dismissal, do I have a record, or how does that show up on my record? Here's how I want you to think about a record. A record is a record of what's happened in your criminal case, okay? I think most folks, when they talk about records, are thinking like a record of a conviction, okay? So if your case has been dismissed and you don't have any other criminal issues, you don't have a record of convictions, okay? But you do, or a record of a conviction, but you do have a record, right? It's the same, it's just the courts need to keep, or should, or whatever it may be, keep notes on what's happened on the individual's case. So if you've been arrested and arraigned, and then your case is later dismissed, you've got a record of an arraignment and a dismissal. If you received a summons complaint and you go up and you've been arraigned, arraignment, such and such date, and maybe 2 months later or whatever the case may be, dismissal, okay? But there needs to be, and there should be, some sort of documentation about that. So do you have a record? I mean, yes, I suppose anybody who's been arrested and arraigned, in some cases, even if the case has been diverted, we can talk about that in another video, you've got some sort of record, some sort of notes about what happened in your case. You don't have a record of conviction in that case if your matter has been dismissed, but you still have a record. Okay? In all my years of doing this, if somebody has an arraignment and then a dismissal for whatever reason, right? I haven't seen that really jam somebody up when their career or otherwise, but I understand why people are asking that question. But yes, a dismissal still shows up on your record in that there's some data or some entry of about what's happened in your case. So on a 30,000 foot overview, that's how a dismissal works. That's how dismissals with prejudice and dismissals without prejudice work. Again, attorney Nate Amendola, Nate Amendola Defense, criminal law in plain English.